If you're a gun owner and you don't know about what just happened at the Supreme Court, you could be committing a felony right now without even realizing it. And here's the scariest part. This wasn't just about your Second Amendment rights. This was about your Fourth Amendment protection against unreasonable searches. And the combination of these two rulings just changed everything. Quick question before we continue. Are you subscribed yet? Because what I am about to reveal involves a unanimous Supreme Court decision that rewrote the rulebook for gun owners and anyone who values their privacy rights. Hit that subscribe button right now because 90% of Americans have no idea this even happened, and the consequences start immediately. Here's what just went down at the highest court in the land. On January 15th, 2026, the Supreme Court handed down a unanimous 9-0 decision in the case of Martinez versus United States. This wasn't a close call. Every single justice agreed. And when the Supreme Court speaks unanimously, you better listen, because it means the legal landscape just shifted under your feet. Let me tell you the story of Carlos Martinez, because his case is about to change how police can search your car, your home, and your person when firearms are involved. Martinez was a licensed concealed carry holder in Arizona. Clean record, no criminal history, law-abiding citizen. He was driving home from work one evening when he got pulled over for a broken taillight. Routine traffic stop, right? Wrong. When the officer approached his vehicle, Martinez did everything by the book. He kept his hands visible, was polite, and respectful. Arizona is a duty to inform state, so when the officer asked for his license and registration, Martinez said, "Officer, I want to let you know that I'm legally armed with a valid concealed carry permit. How would you like me to proceed?" This is where things went sideways. The officer immediately ordered Martinez out of the vehicle. Then he patted him down for weapons. Then he searched the entire car for additional firearms. Then he called for backup. What started as a simple traffic stop turned into a 45-minute roadside investigation. Martinez's gun was temporarily confiscated. His car was searched from top to bottom. And even though he had done nothing wrong, he was treated like a criminal. But here's where it gets interesting. During that search, the officers found something else. In Martinez's glove box, alongside his registration and insurance papers, they found a small notebook. Inside that notebook were what police later described as suspicious notations. Actually, just Martinez's hunting diary where he recorded deer sightings and weather conditions. But the officers decided these notes looked like surveillance records. They seized the notebook, they photographed it, and they used it to justify searching his home 3 days later. At his house, police found Martinez's legally owned gun collection, 12 firearms, all properly registered, all legally purchased, all stored according to Arizona law. But because of the suspicious notes and the traffic stop, police decided to conduct what they called a weapons investigation. They photographed every gun. They ran serial numbers. They questioned Martinez's neighbors. They contacted his employer, all because he exercised his legal right to carry a firearm and informed police as required by law. Martinez fought this in court. His lawyers argued that the extended detention, the vehicle search, and the home search all violated his Fourth Amendment rights against unreasonable search and seizure. They said that simply being armed with a valid permit cannot justify turning a routine traffic stop into a criminal investigation. The government disagreed. They argued that officer safety concerns justified the entire sequence of events. The case bounced around the federal courts for 2 years. Some judges sided with Martinez, others sided with the government. The legal standard was unclear. Could police automatically extend a traffic stop and conduct a search just because someone legally possessed a firearm? Did informing an officer about your weapon create reasonable suspicion for further investigation? What level of search was reasonable when guns were involved? The Supreme Court took the case to settle these questions once and for all, and their answer surprised everyone, including legal experts who thought the court would be divided along ideological lines. Chief Justice Roberts wrote the unanimous opinion. He said that the presence of a legally possessed firearm by itself cannot justify extending a traffic stop or conducting a search beyond what would normally be permitted. The court held that licensed gun ownership is a constitutional right, and exercising that right cannot provide the basis for treating someone as a criminal suspect. But here's where the ruling gets really powerful. The court didn't just rule on the search issue. They went further and addressed what they called the chilling effect on Second Amendment rights. Justice Roberts wrote, and I am paraphrasing here, "If law-abiding citizens know that exercising their right to bear arms will subject them to enhanced police scrutiny, prolonged detentions, and invasive searches, many will choose not to exercise that right at all. This creates an unconstitutional burden on Second Amendment freedoms." The court established a new standard called the Constitutional Rights Nexus Test. Under this test, law enforcement cannot use the exercise of one constitutional right as justification for investigating potential violations of other laws unless they have independent reasonable suspicion based on specific articulable facts unrelated to the constitutional right being exercised. In plain English, that means police cannot search your car more thoroughly just because you legally own a gun. They cannot detain you longer just because you inform them about your weapon as required by law. They cannot treat you as more suspicious just because you exercise your Second Amendment rights. The presence of a legal firearm by itself is not reasonable suspicion of criminal activity. But the court went even further. They addressed the home search issue. Justice Roberts wrote that the same principle applies to searches of homes and other private property. Police cannot use legal gun ownership as a pretext for broader investigations. They cannot seize lawfully owned firearms without probable cause of a specific crime. And they cannot photograph or catalog legal gun collections without a warrant based on probable cause. The decision establishes what lawyers are calling the Miranda for gun rights. Just like police must inform suspects of their right to remain silent, they must now inform gun owners of their right to refuse consent to searches that go beyond basic safety measures during routine encounters. Here's what that means in practice. If you're pulled over and you inform an officer that you're armed, they can still ask you to exit the vehicle for their safety. They can still conduct a pat-down to locate and temporarily secure any weapons. But they cannot automatically search your entire vehicle. They cannot seize your notebooks, papers, or other property. They cannot extend the stop to run background checks or investigate your gun purchases. And they cannot use your legal possession of firearms as justification for any of these actions. The court also addressed the issue of what they called fishing expeditions. Police were using legal gun encounters as opportunities to look for other violations. They would search for drugs, outstanding warrants, parole violations, or other unrelated issues. The court said this practice must stop. A traffic stop cannot become a general investigation just because guns are involved. Now, let me tell you why this matters more than you might think. Before this ruling, gun owners across the country were experiencing what civil rights lawyers called constitutional whiplash. In some states, informing police about your weapon led to smooth professional interactions. In others, it led to prolonged detentions and invasive searches. Some gun owners stopped carrying rather than risk the harassment. Others stopped informing officers, risking criminal charges and duty to inform states. The Supreme Court recognized this problem and decided to fix it with a clear nationwide standard. Justice Thomas, writing a separate concurring opinion, said that constitutional rights cannot depend on geography or the personal preferences of individual officers. The law must be clear and consistent. But here's where it gets really interesting. The court's decision doesn't just protect gun owners, it protects everyone. The Constitutional Rights Nexus Test applies to all constitutional rights. Police cannot use your exercise of free speech rights as justification for searching your property. They cannot use your assertion of Fifth Amendment rights as evidence of guilt. They cannot punish you for exercising any constitutional right by subjecting you to enhanced law enforcement scrutiny. The decision has immediate practical implications. Police departments across the country are scrambling to rewrite their training manuals and policies. The Department of Justice has issued new guidelines for federal law enforcement. And civil rights lawyers are filing lawsuits challenging past convictions that were based on searches that would now be considered unconstitutional. If you're finding this helpful so far, imagine what you'll learn in my next video where I break down the exact words to say during a police encounter to invoke these new protections. Subscribe right now so you don't miss that critical information. Let me give you some specific examples of what changes immediately. First, traffic stops. If you're pulled over and you inform an officer that you're legally armed, they can ask you to step out and they can secure the weapon for safety. But they cannot automatically search your vehicle, your wallet, your phone, or any containers in your car. They need independent reasonable suspicion based on something other than your legal possession of a firearm. Second, home visits. If police come to your door for any reason and they see evidence of legal gun ownership, a hunting magazine on your table, a gun safe visible in your home, or you mention that you own firearms, they cannot use that information to justify a search or seizure. They need a warrant based on probable cause of criminal activity. Third, traffic checkpoints. At DUI checkpoints or license checkpoints, if you inform officers that you're carrying as required by law, they cannot pull you aside for additional screening unless they have specific, articulable suspicions unrelated to your weapon. Fourth, interactions with federal agents. ATF agents, FBI agents, and other federal law enforcement must follow the same standards. They cannot use legal gun ownership as a pretext for broader investigations. They cannot seize legal firearms without probable cause, and they cannot photograph or inventory legal gun collections without a warrant. The court also addressed the issue of gun storage and transportation. Police cannot search gun cases or safes during routine encounters. They cannot demand to see purchase records or registration documents unless they have probable cause of a specific violation. And they cannot treat legal gun transportation as inherently suspicious activity. Now, let me address some common misconceptions about this ruling. First, this does not mean police cannot ensure their safety during encounters with armed individuals. They can still ask you to exit your vehicle. They can still temporarily secure weapons. They can still take reasonable precautions. What they cannot do is use your legal gun possession as justification for broader searches and investigations. Second, this does not mean you should become confrontational or refuse to cooperate with reasonable safety measures. The key word here is reasonable. Courts will still evaluate the totality of circumstances in each case, but now they have clear guidance that legal gun ownership, by itself, is not grounds for suspicion. Third, this does not eliminate all police discretion. Officers can still investigate if they observe specific indicators of criminal activity, but those indicators must be independent of your legal exercise of constitutional rights. The timing of this decision is particularly significant. Gun ownership in America has reached record levels. Concealed carry permits have increased dramatically over the past decade. Millions of Americans are exercising their Second Amendment rights daily. Without clear legal protections, these law-abiding citizens were vulnerable to harassment and constitutional violations. The court recognized that technology has also changed the landscape. Modern vehicles often contain computers, phones, GPS devices, and other electronic equipment that can reveal intimate details about a person's life. If police could search these devices whenever they encountered a legal gun owner, it would create a massive loophole in Fourth Amendment protections. Justice Kavanaugh, writing separately, emphasized the importance of protecting digital privacy in the modern age. He noted that smartphones contain vast amounts of personal information, communications, location data, financial records, medical information, and more. Allowing police to search these devices based solely on legal gun ownership would eviscerate privacy rights for millions of Americans. The court's decision also addresses the intersection of federal and state law. Some states have stricter gun laws than others. Some require registration, others don't. Some have waiting periods, others don't. The Supreme Court made clear that these variations in state law cannot justify different levels of constitutional protection. Your Fourth Amendment rights are the same, whether you're in Texas or California. But perhaps most importantly, the court recognized that constitutional rights are interconnected. You cannot fully exercise your Second Amendment rights if doing so subjects you to violations of your Fourth Amendment rights. Similarly, you cannot fully exercise your Fourth Amendment rights if police can circumvent them by focusing on your exercise of other constitutional rights. This principle extends beyond gun rights. The court as reasoning applies to any situation where police try to use your exercise of one constitutional right as justification for investigating potential violations of other laws. This could affect freedom of speech cases, religious freedom cases, and many other areas of constitutional law. The practical impact of this decision will unfold over the coming months and years. Police departments will need to retrain officers. Prosecutors will need to review pending cases. Defense attorneys will challenge convictions based on searches that are now clearly unconstitutional, and gun owners will have stronger legal protections when they encounter law enforcement. But here's what you need to know right now. If you have a concealed carry permit, familiarize yourself with your new rights under this decision. If you're pulled over, you should still inform officers, if required by your state's law. But you should also understand that your legal gun ownership cannot justify an extended detention or a broader search. If police ask to search your vehicle beyond basic safety measures, you can politely decline. You can say something like, "Officer, I don't consent to any searches beyond what's necessary for your safety. I'm aware of my rights under the recent Supreme Court decision in Martinez versus United States. If police persist or threaten you with consequences for asserting your rights, remain calm but firm. Ask if you're free to leave. Ask if you're being detained and why. Document the encounter if possible. And remember that you can always challenge illegal searches later in court." The Supreme Court's unanimous decision in Martinez versus United States represents a major victory for constitutional rights. It clarifies the relationship between Second and Fourth Amendment protections. It establishes clear limits on police power, and it ensures that law-abiding gun owners can exercise their rights without fear of constitutional violations. This decision will be cited in legal cases for decades to come. It will influence how police are trained and how they conduct investigations. And it will serve as a reminder that constitutional rights are not just words on paper, they are living protections that must be defended and enforced. So here's your action plan. First, learn about this decision and understand your rights. Second, share this information with other gun owners and anyone who cares about constitutional rights. Third, document any police encounters that seem to violate these new standards. And fourth, support organizations that are fighting to protect constitutional rights in court. The fight for constitutional rights is never over. There will always be new challenges, new cases, and new attempts to erode our freedoms. But decisions like Martinez versus United States show that when citizens stand up for their rights, and when good lawyers take cases to court, the Constitution still protects us. Remember, this is educational information about constitutional law and recent court decisions. This is not legal advice for your specific situation. If you have questions about your particular circumstances, or if you believe your rights have been violated, consult with a qualified attorney who specializes in constitutional law and criminal defense. The Supreme Court has spoken. Constitutional rights matter, and law-abiding Americans deserve protection when they exercise those rights. This unanimous decision ensures that protection will continue for generations to come.